Hello, my name is David Winch. I'm a chartered accountant with Bartfield's Forensic Accountants. And in this webinar, I'm going to be focusing on the how much question, as I've called it, in confiscation. Let's have a look at the agenda. The how much question, and then I'll talk about the critical review of the Section 16 statement, analysing transaction data, the defendant's explanations and how we weave those into how we deal with the confiscation proceedings, and the actual forensic accountant's report. And then I'll say a little bit about instructing us, and of course I'll finish with how we can help you. So the how much question. What I wanted to look at here was the difference between the focus in a trial and the focus in confiscation. Of course, in the trial, the issue is the defendant guilty or not guilty? And the value of the offence, let's say it's a fraud, can be very much a secondary consideration. I've seen cases, for example, where a trial has gone on and the thrust of the defence case, if you like, in a conspiracy, I'm thinking of a particular conspiracy, the thrust of the defence case was, yeah, there was a fraud, but I was not involved with it. It was the other guys and not me. Now, one can imagine how in putting the defence forward, the defendant's representatives didn't stress the detail of how much was involved in the fraud, because for them that was irrelevant. The point was that their man was not involved in it. As things turned out, the jury thought that he was involved and he was convicted. And then we reached a point where confiscation came along, and we hadn't at that stage had a detailed cross-examination of the prosecution witnesses who were dealing with the amount of the offence. So that evidence had gone effectively unchallenged, as each of the defendants was blaming the other for the fraud. Well, the result, of course, in confiscation is that you have a difficulty in that there is now unchallenged prosecution evidence of the amount of the fraud. And the defendant coming along at confiscation stage and trying to argue the amount, that ship has rather sailed because he's been found guilty and evidence has not been contested at the trial stage for sensible reasons. So there can be a difficulty in confiscation which results from the different focus from the trial and the confiscation. And another point that happens on confiscation is that very often the indictment actually won't specify the amount involved. And so you have a conviction for an unspecified amount, and then we come on to confiscation, and the focus in confiscation, of course, is very much on how much benefit was obtained by this defendant. And that's a question that perhaps hasn't been addressed very much at all in the trial. Another point about confiscation is that the time period, particularly in a criminal lifestyle confiscation, and most of the confiscations that I deal with are criminal lifestyle confiscations. The time period that's under investigation in confiscation can be different from, and it is very often different from, the time period which is under consideration at trial. The indictment period, if you like, the period over which the offence was committed. Because, of course, in a criminal lifestyle confiscation, you are typically looking at a period that begins 6 years before the day, on which the defendant was charged. And so that can go back way earlier than the period of the offence. Or indeed, you may actually have a situation where the period of the offence goes back prior to the 6-year period, or prior to the relevant day, as it's known in confiscation. So you're looking at a different issue. One sometimes feels that when confiscation was legislated for, the thinking was that it would follow straightforwardly, almost automatically, on sentencing. That it was just a simple job to sort out the confiscation as a result of the trial and the sentence. And it's not. It's actually a rather different task altogether. And one of those differences is that there may be evidence which is admissible in the confiscation proceedings, which would not have been admissible in front of a jury. The thinking is that the judge, of course, is a seasoned legal practitioner. He is well able to have in mind the issues that might arise in respect with hearsay, for example, so that he is able to place appropriate and not excessive weight on that sort of evidence. But it can come as a surprise to the defendant to find that evidence is admissible in the confiscation proceedings, which would never have been allowed to be put in front of a jury. And of course, the burden of proof is much more weighted towards the defendant in confiscation. And the standard of proof is the civil standard, the balance of probabilities. The burden of proof is not wholly on the defendant. Sometimes people think it is. There is an initial burden of proof on the prosecution. It is, for example, for the prosecution to show the benefit of the offence. And it is for the prosecution to show that monies or transactions or property are susceptible to being caught by the statutory assumptions of Section 10, the criminal lifestyle assumptions. So the very first initial burden may not be a heavy burden, but the very first burden falls upon the prosecution, even in a criminal lifestyle confiscation, even where they are relying on the statutory assumptions. So, for example, what I'm saying is there's a statutory assumption that says money is transferred to the defendant after the relevant day are proceeds of our benefit of his general criminal conduct, unless that assumption is rebutted. So what the prosecution have to do is to show that there has been a transfer to the defendant after the relevant day. That's all they have to show. But they do have to show that first before the assumptions then kick in. And of course, in confiscation, you've got available amount issues that are just totally irrelevant in a trial. And finally, where a person has been subject to confiscation previously, then that can have an impact on the current confiscation. So if you've got somebody who, let's say, has been subject to a previous confiscation which was based purely on offences, purely on his particular criminal benefit. But at that time, he was not ordered to pay the whole amount of that benefit because his available amount was too low. Well, the benefit which he's never been ordered to pay will drop into his new confiscation. And so we'll have a direct and immediate benefit in terms of a direct and immediate impact in terms of his new confiscation proceedings. And where you've got somebody who's had a previous criminal lifestyle confiscation, and then let's say within 2 or 3 years afterwards is convicted again and is subject again to a criminal lifestyle confiscation, then you've got the various provisions of Section 8 and Section 10, which are designed to prevent double counting of benefit, designed to prevent an overlap of periods in which the assumptions are applied. And that's a little bit too detailed for us to go into right now because we'll run out of time. So what does the forensic accountant do? Well, one of the things he's going to do is to critically review the Section 16 statement. or statements, because there may be more than one. And there are a host of matters which are required to be covered in a Section 16 statement, or ought to be covered in a Section 16 statement and its appendices. So the first thing the forensic accountant's going to do when he's instructed is to have a look through the Section 16 statement and see what issues arise. And of course, the author of the Section 16 statement, who may well be an accredited forensic financial investigator, an AFI, perhaps employed by the police, the author's approach in preparing the Section 16 statement and in coming up with a first figure, if you like, a first shot at the defendant's benefit and available amount, is going to be influenced by his or her understanding of the facts of the case, which of course is based on a prosecutor's understanding of the facts of the case, and his or her understanding of confiscation law. And as we know, confiscation law is not entirely straightforward. Some Section 16 statements are brilliantly written, are very well done, and it's clear that the AFI who's written it does understand the law, does understand the case. Others, not so. Bear in mind the Section 16 author may not have been previously involved in the investigation or in the trial. So they may have a limited understanding of what has gone on. You may be better placed than they are to understand what's gone on. The Section 16 author will have, the AFI will have the defendant's Section 18 statement, but may have a very limited understanding of the defendant's financial affairs, and indeed those of the defendant's family, which can be relevant. I've lost count of the number of times where I've seen assets might be held in the name of a defendant, and the defendant will turn around to his solicitor and his forensic accountant and say, yeah, that is in my name, but it's not my asset. It belongs to other members of the family, or it partly belongs to other members of the family. Now, that sort of information may not be available to the author of the Section 16. So you might get, in the Section 16 statement, a misunderstanding of the defendant's financial affairs and his situation. A forensic accountant, on the other hand, briefed by the defendant's legal team, can be in a much better situation to understand what's going on. The author of the Section 16 statement is likely to have had information from HMRC. It may be as simple as saying, well, there's no record of this defendant at HMRC, or it may involve information from tax returns, from VAT returns, perhaps from corporation tax returns if a company is involved, and so on and so on. Pay-as-you-earn returns. That information may not be fully understood by the AFI who writes the Section 16 statement, because that's likely to be somebody who's not a qualified accountant and who doesn't have experience of preparing tax returns, who doesn't have experience of, for example, dealing with a small business and the sort of records it keeps, doesn't perhaps understand the difference between gross receipts which are banked in relation to a business which is VAT registered. You can have gross receipts which are banked, will include VAT. The figures on the tax return, on an income tax return, will be exclusive of VAT. That's perfectly proper, but that will mean that the declared turnover of a business in its tax returns will be less, perhaps, than the money that's been banked. And that can be perfectly ordinary, perfectly proper, not indicate anything wrong at all, but the AFI may misunderstand that as suggesting that there is undeclared income. And what you've actually got is VAT that has been collected and accounted for to HMRC. So again, the forensic accountant who will have experience of these sort of things will be in a position to understand the figures and to put the correct interpretation on information that has been submitted to HMRC. When we get instructed in a confiscation case, ordinarily there are bank statements and we analyse those bank statements. We have special purpose software for analysing that transaction data. So I'm sure do other forensic accountants. So indeed do the police and the author of the AFI. But getting that information from bank statements into a piece of software where you can interrogate it, where you can look for patterns, where you can look for links between withdrawals and deposits and so on, is one of the key areas that we get involved in when we're instructed in confiscation proceedings. It's a very powerful aid in identifying patterns of transactions from which inferences can be drawn. And of course, we have to be careful to look at what inferences have been drawn in the Section 16 statement and to see if they actually stand up to scrutiny. We also, of course, where we're instructed by the defence, have the benefit of the defendant's explanations. I've said here a good forensic accountant will critically review the defendant's explanations, and certainly that is part of the art, if you like. One doesn't accept a defendant's explanations uncritically because it may be that he is being somewhat romantic with the truth and that it won't stand up in the witness box. Obviously, one is thinking that ultimately, in a confiscation, one may be, as a forensic accountant, in the witness box, subject to cross-examination. And you don't want to be in a position where you're going to get ripped to bits because you've accepted some explanation from the defendant, which is just fanciful. But the forensic accountant can also advise the defendant's legal team on the strengths and the weaknesses of his position. And I often find that as well as writing the report which goes to court, I'm also in discussion with my instructing solicitors and counsel and pointing out where there might be exposure to cross-examination from the point of view of there being weaknesses in the defendant's case. Ultimately, then, I'm going to put together a forensic accountant's report which will examine every element of the asserted benefit and the available amount. Now, I know a lot of solicitors will feel that they can do that themselves, but perhaps they are doing it without the benefit of the software, without the benefit of the detailed analysis, without the benefit of the knowledge of tax procedure and so on. And also, if the solicitor is doing this purely for himself, then if you get to a contested hearing, and I appreciate that in many cases in confiscation, you ultimately do not get to a contested hearing. But if you do get to a contested hearing, then if you've got a forensic accountant's report, of course, you can put the forensic accountant in the witness box and he can give evidence, give explanations, explain to the court what work he has done, what inferences he has drawn, why he has drawn those inferences, and he is a credible, independent witness, whereas just putting the defendant himself in the box, the court may not feel that he's a credible, reliable witness. So yeah, having the forensic accountant's report serves various purposes. Because it goes to the other side before the hearing, it assists the defence and the defendant and his legal team or her legal team in presenting the defendant's case. And very often what happens in practice is that after our report has gone in, a revised Section 16 statement comes back from the prosecution. Now, sometimes that revised Section 16 statement actually has higher figures of benefit and higher figures of available amount than in the first place. But that's not a sign that things are going wrong. That's simply a sign that the ball is in play, as it were, and that we are debating the strengths and weaknesses of the case. Equally, very often, large chunks of the benefit may have got chopped out, or chunks of available amount may have got chopped out as a result of the prosecution accepting the forensic accountant's evidence and accepting that various items can be explained or do not form part of benefit for some other reason, or do not form part of the available amount for some other reason. The cost, well, the cost is usually covered by legal aid. So in a sense, the defence is in a position where it can win and cannot lose from appointing a forensic accountant. The cost is covered by legal aid if the forensic accountant's report is totally unhelpful, if there's nothing good that comes from it. I'm not sure that's ever happened to me, but I suppose it could happen. If there is nothing good, then of course the defence do not have to release it to the prosecution. They can simply say, thank you very much. We realise we're in serious bother here. We're not going to disclose your report. We're not going to call you to give evidence at the hearing if there is one. But what you've said is useful. At least we can advise the defendant how difficult his situation is. So worst case is, if you like, you simply get a report which is going to help you advise the defendant that he's in serious bother, and the cost is covered by legal aid. Forensic accountants, of course, being accountants, are always directing their minds to questions of how much. It's what we do. We ask ourselves how much. We evaluate things. We look at business records, we look at bank statements, we look at all this sort of stuff. So this very much is home ground for us, perhaps more so than for solicitors and counsel. And added to that, we do have specific accounting knowledge of accounting records and of tax. In a sense, the forensic accountant acting in a confiscation is in large measure, although he is an expert witness, in another sense, he is not acting as an expert witness, he's acting as a skilled witness in drawing information together, analysing it, and not using perhaps specific accounting skills, but using number skills and his numerical analysis of data. So although he's described as an expert witness, he is a skilled witness and an expert witness, and the expert witness bit comes in where we're talking about looking at accounting records, looking at how figures have been put together, looking at how tax returns are done, looking at tax liabilities and that sort of thing. But a lot of what we do, I suppose, is not strictly expert in the sense that you might find an expert accident investigator who can measure the length of skid marks on a road and tell you how fast the vehicle was going. So it's a more general skill and expertise that the forensic accountant will be bringing to you in confiscation. Of course, the prosecution AFI is not an expert in the sense of not an expert witness, because he or she is not independent of the prosecution and is not there to bring a particular technical expertise. The AFI is acting as a skilled witness rather than an independent expert. Sometimes judges will ask for a meeting of experts in confiscation, And we're always happy to meet the author of the Section 16 statement. I do cringe a little bit when I hear judges say we're going to have a meeting of experts, because there's only one expert in the room, and that's me. We have to let that go, I think, and say, right, we are meeting, we're going to have a useful meeting to discuss the figures and the details of the records, and see if we can agree on the facts. Of course, an experts meeting is not a mediation, it's not a negotiation. The forensic accountant is not representing the defendant. He's not able to agree anything on behalf of the defendant. He is an independent expert witness. So the forensic accountant's report, well, yeah, we produce the report and we can also attend the confiscation hearing. And I've said here, and give all evidence if required. In practice, usually what happens is we attend court, get there, and everybody sits down. I'm sure you know this procedure. We all sit down in our own little rooms and we have a bit of a chat, and we say, this is the strength and this is the weakness. And then counsel go off and have a chat with the other counsel and come back and say, oh, what about this and what about that? And 9 times out of 10, something is agreed. And I do think it's useful on those occasions for the forensic accountant to be there at the court, to advise the legal team and also to advise the defendant. And sometimes it is a matter of saying to the defendant, look, I know you feel sore about this. I know you feel this isn't quite fair, but this is the problem that you've got. This is what you're being offered. This is what you might face if you turn down the offer. And this is what could happen. And judges, let's be honest, are not wildly enthusiastic about accepting unsupported evidence from somebody who's just been convicted of an offence. And sometimes it's useful for everybody, for the forensic accountant to be there and to be able to have his two penneth, if you like, in front of the defendant as to how things stand. And that's what I'm saying on the slide. It's very useful to have the forensic accountant present for those discussions. So, having persuaded you perhaps that it would be advantageous to instruct a forensic accountant, how do you go about it? Well, first thing to say is that we're always happy to look at a case on a no obligation basis and to say, this is a case where we think we could help in these areas, or even this is a case where we don't think there's anything useful we could do. Again, that is rare. It does occasionally happen. And of course, we will put together a fee quote for legal aid purposes. It is useful initially to have at least a copy of the body of the Section 16 statement and an indication of the number of pages of appendices, just to give us a clue as to the size of the task which is going to be facing us if we're instructed, so that we can do a quote. If you know the number of pages of bank statements that we're going to have to analyse, that information would be useful as well. But if not, don't worry, we can handle that later. And then the appendices and the Section 18 statement and the Section 17 statement, if you've done one, they can all follow later. Well, as I've said before, we are, sadly, we're still in this pandemic. We look as if we may still be facing some sort of pandemic restrictions from the government for months to come. But Bartfield's Forensic Accountants does remain fully staffed. We're undertaking legal aided and privately funded criminal and civil forensic accountancy work. Happily, it's relatively easy for us to conduct the bulk of our work remotely, although in practice we are now spending more time in the office than we were in, say, April. But the bulk of our work can be done remotely. We have up-to-date and secure IT facilities. We are readily contactable by phone, by email, and online. And our recently updated website is full of useful information, which of course is accessible 24/7. You can find more on this and other topics on our website at the address there. And this and the previous webinars can be found in the seminars area of the website. Again, the address is on the slide. We will send you a recording of this webinar so that if you feel you've missed any key bits, you can listen again. And please, if you've got questions, do email me. I should be more than happy to answer them. Again, the email address is on screen there, and the phone number also. Thank you again for your time. We've just about run out of 30 minutes, but thank you very much. I hope you found this useful. In a fortnight's time, we are going to be talking about the Law Commission consultation on confiscation law. There's a good 600 or 700 pages of documents that the Law Commission has recently published. And we'll have a chat about that in a fortnight. Thank you very much.